I want to chat with you today about the independence of the licensed insolvency trustee acting as a court-appointed receiver. The decision of the Court of Appeal of Alberta released on February 4, 2019 in JCAP Financial Limited v. Snowden Block Incorporated, 2019 ABCA 47, JCAP, highlights the issue. To better understand the JCAP decision, I want to talk about a few basic points. In a private receivership, the receiver's primary duties are to act on behalf of and have a duty of care primarily to the secured creditor who appointed the receiver, in a commercially reasonable manner, lawfully. In a court appointment, the court-appointed receiver acts on behalf of the court as a court officer, and be seen to be independent of all stakeholders, owes a duty of care to all stakeholders, must act in a commercially reasonable and lawful manner. Various practices have evolved over time to indicate the independence of the court-appointed receiver. They aren't necessarily rules or laws. However, they are indicators that the court looks to in determining if its court-appointed receiver is seen to be independent and is actually independent of specific stakeholders, normally, secured creditors. Examples of these indicators are: the court-appointed receiver has its own legal counsel and does not rely upon legal counsel for one of the secured creditors. The court's receiver has obtained sufficient independent appraisals of the assets and has not taken the word of or prior appraisals commissioned by a secured creditor. A sales process being recommended by the court-appointed receiver is fair to all parties and does not favor one or more stakeholders over others. The analysis performed by a court-appointed receiver in making its recommendations to the court is seen to be free from undue influence. The court-appointed receiver has not shared its appraisal or other information which could influence the outcome of the receivership administration with any of the stakeholders. The court-appointed receiver has not treated some stakeholders differently than others. Any information shared by the court-appointed receiver or meetings held to share information has been done with all secured creditors, not just a senior secured creditor or the secured creditor who made the court application to appoint the receiver. The receiver was appointed by the court as receiver and manager of Snowden Block Incorporated, Snowden, in February 2016. The only material possession of Snowden was land and building in Calgary. JCAP was the primary lender of Snowden and was funding the receivership. JCAP became interested in capping the increasing costs and safeguarding its financial investment. The receiver advised JCAP that a credit bid would be a feasible option to get title to the real estate and bring the receivership to an end. JCAP submitted an agreement of purchase and sale which the court approved. The receiver then went back to court with a different agreement indicating there was a mutual mistake made in the first application. Under the first APS, there was no shortfall and therefore the guarantors had no liability. Under the second APS, there was a shortfall in excess of $1 million that the guarantors would be responsible for. The guarantors appealed the approval of the second APS specifying that the court erred in finding there was a mutual mistake. Further, the guarantors say that the receiver's conduct casts doubt on the honesty of the process. They say that the receiver did not discharge its independent obligation and was following guidelines and instructions from JCAP, that had a change of mind about the transaction and wanted to minimize the price. Their position was that the second approval and vesting order needs to be vacated, the first APS ought to be reinstated, and the guarantors should be alleviated of their responsibility under the guarantee. The Court of Appeal of Alberta agreed with the guarantors that the evidence did not support a mutual mistake was made. As far as the conduct of the receiver, the appeal court said that while insolvency proceedings undergo special procedural rules and are not surprisingly time-delicate in nature, these considerations do not relieve the receiver from its basic responsibilities to the stakeholders and the court. Also, it does not excuse the receiver from supplying proof to fulfill its requirement to provide sufficient evidence to the requisite standard for each application that it brings. The appeal court went on to say that a court-appointed receiver is an officer of the court appointed to discharge certain duties listed in the appointment order. When a court-appointed receiver is appointed, the receiver-manager is given exclusive control over the assets of the company and in this regard, the board of directors is displaced. The significance of a receiver's power is to clear up liabilities and sell off assets. It is well developed that a court-appointed receiver owes a duty of care not just to the court, but likewise to all parties who may have an interest in the debtor's assets. This includes competing secured creditors, guarantors, unsecured creditors, contingent creditors and shareholders. A receiver has the duty to work out such reasonable treatment, supervision and control of the debtor's property as a regular person would give to his or her very own. A receiver's duty is to perform the receiver's powers truthfully and in good faith. A receiver's responsibility is that of a fiduciary to all interested stakeholders involved with the borrower's assets, properties. The appeal court was harsh in its criticism of both the receiver and JCAP. The court found that the absence of details about what occurred and the method the receiver and JCAP used to skirt around the issues in its application materials definitely did not assist in showing the receiver's independence. The optics of the circumstances most likely added to the guarantor's uncertainty that what had taken place warranted even more inquiries and that the receiver was following JCAP's instructions to conceal from the guarantors the real state of affairs. JCAP and the receiver were jointly represented by the same legal counsel before the Alberta Court of Appeal, which was unhelpful and was in the court's view, highly unusual. JCAP could not address questions the receiver would be anticipated to know. Throughout the hearing, the panel discovered that the guarantor's arguments were convincing. The appeal was allowed, and an order was made returning the matter to the lower court for a rehearing before a different judge. Does your company have too much debt and is in danger of shutting down? Are you concerned that future interest rate hikes will make currently manageable debt totally unmanageable? Is the pain and stress of financial problems now negatively affecting your health? If so, contact the Ira Smith team today.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting over, starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now. Ow.